Welcome. I'd like to welcome you to this first seminar on the Department of Defense Directive 5220.6. Today's topic is very important. It's one of the most prevalent and frequently cited allegations against people seeking a security clearance. And of course, I'm talking about guidelines B and C under the Directive 5220.6. If you don't have that directive, please call my office and there will be contact information contained in this seminar for you to call us, and we'll be pleased to send you a copy of the directive. Part of the problem for most applicants is that they don't read the directive and they don't understand it, and that's what we're going to talk about today. My name is Alan Edmonds, and I've been a licensed attorney for over 34 years. I've handled and helped national security applicants around the globe and have written a book and taught many attorneys in this area of law. It's a fantastic area of law, and the good news for you today is that if you are from another country and you're working in the United States and you've applied for a security clearance, I don't want you to give up. You can win these cases. My law firm wins them all over the United States and Europe, and we post many of these victories on our website. So if you haven't done so, please visit our websites, and they will be also listed in this seminar. But nationalsecurityclearances.com and securityclearancedenial.com are websites that contain a tremendous amount of information for you, and it's free. And you can also look at the cases, scroll through all the cases on those websites, and you'll be amazed. Those are the cases where I've helped men and women get their security clearances. They started out with a security application on their own. They lost the initial decision, and then they called my office, and things changed. And you'll also see some testimonials on that site, because really what we're talking about here is something much larger than getting a security clearance. We're talking about your career. And I have been fighting for your careers across this country of ours, and in Europe and in Asia, for over 3 decades. And I love representing people that are hardworking and can make a valuable contribution to this society, but in my opinion, are being arbitrarily denied a security clearance. So let's turn to the instruction, because Guideline B and Guideline C, which is foreign influence and foreign preference, are very significant and important sections in the directive. As I said earlier, they're the sections that are used most frequently by the government to stop you from getting a clearance. The directive contains a tremendous amount of information, and this directive applies not only to some of the DoD sections, but it also applies to other agencies. And that's important for you to understand. The Department of Energy and Department of Commerce may be separate agencies than the Defense Office of Hearings and Appeals, but all of these agencies, including NSA, DIA, the CIA, the FBI, they borrow language from one another, and they come up with their own directives in some instances, but they're actually identical to 5220.6. So if you need a copy of this directive, please call my office, 1-800-481-2526. We'll be happy to send you a copy of the directive. One of the frequent questions that arises about a security clearance application is what can your employer do when they learn that the Department of Defense is withdrawing your security clearance or suspending it? And the answer is that it's really up to the employer. They can find another position for you. They can escort you off the premises immediately, and they can terminate employment. Many people wonder, what is the next step? They get a written notification from the government called a statement of reasons, and they call me and they say, what do we do now? And the answer is contained in the directive, and the answer is quite simple. You have to respond to the statement of reasons. The statement of reasons contains allegations, and we're going to talk about two of those allegations today, Guideline B and Guideline C. But the statement of reasons, or the LOI, the letter of intent, contains the allegations in specific language and detail for you to respond to. Now, I may be leaving you with a false impression because I said that the allegations are something that you should respond to, and that's not the way I believe you should respond. I think that because your career is in balance, you should give this to an individual, an attorney that has experience, that has a track record in how to succeed. Many of you are brilliant scientists, mathematicians, IT people. I know because I've met you. You're very, very impressive. But when it comes to this area, you misunderstand the requirements of the regulations. You try and do it yourself, and I admire that, but you make mistakes that you're totally unaware of that are being made by you. So, since this is your career, and if you lost your job, what would you do? Since it's of that gravity, I'm suggesting to you today that you have an experienced professional respond to your SOR. The statement of reasons is not simply admitting or denying allegations. The response allows you to attach documents, exhibits, and also present some legal arguments. And unless you've done that for years and years, you're simply going to have a difficult time. Some individuals try to respond themselves, they lose, and then they call my office. I get these calls from wonderful people all over the world, and they say, well, I did it myself. I thought it was easy, and I lost. What do I do now? The problem that exists for me and my staff when individuals respond themselves is that they've made statements in their response that now we have to live with. Your written response becomes part of the record in this case. And so if you've made some errors or you misunderstood the allegations and you attempted to respond to those allegations, that becomes part of the record and can become an inconsistent statement at the time of the hearing. When we handle these cases, my staff and my attorneys, we actually point your case toward a hearing. Even when we respond to the statement of reasons, which provides us an opportunity to win at an early level, we still think in our minds we have to prepare for the formal hearing. I'm happy to say that you can win these cases with the written response if you know how to do it. The statistics show that most people do not stop this process and get their clearance simply by the written response. But again, I invite you to my website. When you go, you will find not only cases that I've won at the formal hearing stage, you'll see something highly unusual. You'll see cases that I have won with a written response to the statement of reasons. What a better result could you have? It saves you an incredible amount of money. It saves you the trauma of going to a formal hearing, and it allows you to get on with your career at an early stage. So don't be dismayed. One of the themes that you're going to hear repeatedly in this seminar today on Guidelines B and C is that you can win. Okay, let's move on. The next area that I'd like to talk about, after you've gotten a copy of the directive, 5220.6, and you've looked at it, and you've got your statement of reasons, and you've looked at that, then you're going to get on the telephone and hopefully call my office for a discussion, which would be free. We'll go over the ramifications of what the government is saying in the SOR, and we'll outline for you the type of evidence you're going to need to overcome this case. The guidelines talk about some of the evidence in very general terms, and they also introduce you to a concept called the whole person concept. And that's extremely important because at the time of hearing, my presentation on your case is not only a detailed rebuttal of the specific allegations, but I want the hearing officer to know about you. I want them to know your background, your education. I want them to know about your family because it creates a very favorable impression, and that is exactly what the regulations talk about, which is the whole person concept. And we think at my law firm that that is a tremendous opportunity for you to win this case. Most of the time when we have Guideline B and Guideline C cases, we represent wonderful people with incredible educational backgrounds and incredible IQ, and they have one major problem, and that is English is a second language. And if you went to that hearing yourself and you were representing yourself and your English skills were not adequate, that would make your hearing a very difficult event, especially if you're nervous and you've never done a hearing before. That even makes your English skills and your speaking skills more difficult. For Guideline B and Guideline C cases, we stress that you should never represent yourself. It's just too difficult. And I say that knowing how intelligent and bright my clients are in this area, but they misunderstand the process, which I'm going to talk to you about in a few minutes, and they misunderstand the roles of the government attorney and the hearing officer. And I want to talk about that now. Frequently, I get telephone calls from people like you that went to the hearing. They answered their SOR, and they didn't see any pitfalls, and then they went to the formal hearing by themselves, and they call me sometimes within an hour of getting out of that hearing, and they say to me generally the same thing. You wouldn't believe how hostile the environment was, or how I was treated with such disrespect by the government attorney or even the hearing officer. These are the comments that we get from you. And what happens is that you reach out to the government attorney before the hearing, and they respond in a manner that leads you to think they're your friend. You should understand something very clearly from this little seminar, and that is that the government attorney has one agenda, one purpose, and that is to ensure that you don't get your security clearance. No matter how friendly they are, no matter how they seem to assist you or tell you, you don't need a lawyer, you can do this yourself, that all changes in the courtroom and they have a job to do. And suddenly, you're looking across the courtroom at an individual that was your friend, apparently, prior to the hearing, and now they are saying the most derogatory comments about you, and you're absolutely amazed and stunned. And you don't know what to do. Another problem that exists is that when you get into the courtroom, you meet a total stranger, and that's the hearing officer. I've been doing these cases for over 30 years for active duty military and civilians, and like any career, there are some outstanding judges, men and women that are dedicated to upholding this directive, this 5220.6. And the directive says, there is language in the directive. When you get it, look at pages 3 and 4, and it says, all proceedings provided for by this directive shall be conducted in a fair and impartial manner. That language is right there. And if you're confronted with a situation where you're being treated disrespectfully in the courtroom, or you're being criticized or interrupted, then the issue that arises is, are you being treated fairly and impartially? And what would you do if the situation in the courtroom deteriorated to such a level that you didn't know how to respond to the government's conduct or the demeanor of the judge? What would you do? And that's precisely why I'm talking to you today, and I'm spending this time educating you about the reality of this experience that you're embarking on. This is a road that impacts your life and career, and the first step is the notice by the government that your clearance is going to be revoked. The second step on that road is the statement of reasons. The third step on that road is your response, or hopefully the response of your trained legal counsel to that SOR. The fourth step on that road is the preparation of your trial notebook. How many of you have prepared a trial notebook? How many of you have cross-examined witnesses? How many of you know how to conduct a direct examination of yourself on the witness stand? And how many of you know how to object to evidence that the government is going to offer against you? And that's just a few of the dangers that exist when you represent yourself in these hearings. So ask yourself, how important is your job? And how important is your career? Because if you lose all of these opportunities along the road that I've talked about earlier, if you lose at each step of the way, what is the end result? And the end result is that you're out of a job. What will you do? So that's the significance of what we're talking about today. It's not just getting the clearance. Getting the clearance is definitely a goal, but let's look about the reality of the ramifications. And the ramifications are you're unemployed. So let's move on now that we've discussed this directive, and let's go right to some of the other areas that you folks call me about. And you have questions because you want to know what's the correct response. And I regret that I can't give you legal advice over the phone. And I tell you that because you're not a client of the firm. And I can't give you legal advice today because I'm speaking to hundreds of you today, and you're not my clients. This is a seminar to give you a general working knowledge of the application process and the ramifications of the directive when you lose and have to file an appeal. One of the big areas of question that I hear from you people is, I received a phone call for a polygraph, or I received a phone call and some investigators want to talk to me. Do I have to participate? And the directive on page 7, paragraph 6, speaks to that situation. And it says, applicants shall be investigated in accordance with the standards of DoD Directive 5200.2. What does that mean? In simple terms, it means, yes, you have to submit to a polygraph, and yes, you have to be interviewed by investigators. Wow. How many of you out there have taken polygraphs? And how many of you out there have been investigated by trained investigators? My law firm offers a service just for preparation for those two experiences. We talk to our clients about how to conduct themselves in investigations, And we talk to our clients about polygraphs. And the directive continues by indicating you have to cooperate fully with that process. I've had people that have left a polygraph. They had a difficult time, they left it, and then they wanted to return a month or 3 months or 4 months later. They said, "Can I do that?" And that's a very difficult situation. And if you call my office, I'll tell you about some of the steps that you have to take. So let's review. We've talked about, in general terms, the necessity for you to look at 5220.6. Get the directive. Next, you've got to read it. And the directive contains a number of allegations that can be used against you, 13 in all, but today we're only talking about 2, and that's the second and third allegations, Guideline B and Guideline C, because I've told you they're the most frequently cited for people that are coming to the United States from outside of our borders. So I told you to examine the regulations, and I've given you some insight into the statement of reasons and the response and how important it is. Because remember I said earlier that the response to the SOR can be used against you later, even with an attorney at the hearing stage. But that's okay. I've done this for so long that there's not a problem you're going to bring to me that I can't fix or modify so that it doesn't have the negative impact that you may have created unknowingly when you responded to the SOR. I've also alerted you to the dangers of trying to make friends with the government attorney or the judge. That's not their role. They aren't there to be your friends. They have one goal, and that is to ensure that you don't get your security clearance. The judge, ironically, has an obligation to run a fair and impartial hearing, but what you're going to experience is that the judge gets to ask you questions as well in the hearing. It's almost as if the judge has left his seat in the center of the courtroom and joined the government attorney, because they're both going to conduct an examination about you and to you, and what will you do? I can tell you. I can handle that situation, but I want to alert you that that can occur in the courtroom. You can be sitting in the witness stand and turning to the government attorney 1 minute, only to have the judge interrupt the government attorney and start their own questioning of you. You've got to be prepared for that. That's one of the major functions of the Edmonds Law Firm. We prepare our cases, our evidence, our clients, and our witnesses for these hearings. And we do it in such a way that we win many cases. No attorney wins every case. But please, I invite you to visit my website, scroll through the victories, and find another law firm that does as well on a national level. From San Diego to Afghanistan, from India to Europe, I've represented people from dozens of countries, and I've helped them, and I can help you. Let's move on. The guidelines that we're really talking about today are Guideline B, which is foreign influence, and what is the government looking at or alleging about you. Let's say you come from South Korea, Vietnam, or you come from Iraq or Iran or Egypt. The government is saying that you have divided loyalties, that you still have one foot in the country where you were born, and you have another foot in the United States, that you have divided loyalties, or you have interests in the country where you came from that you still have in existence. What kind of interest could those be? Some of the most obvious are bank accounts. If you have bank accounts in a country that you've come from, that's a concern to the United States, and they believe that that creates a heightened security risk. The administrative law judge wants to know at the conclusion of your case that you are loyal to the United States. If you are still voting in elections in Israel or Canada or India, then you have divided loyalties and you're exercising rights of citizenship in those foreign countries. That will undermine your application for security clearance in the United States. If you own a house in Jerusalem, or if you own a house in Kuwait City, or a house in Vietnam, then you have divided loyalties and interests, and you have property interests in these foreign countries, and that creates a heightened risk. Guideline B is also concerned about foreign individuals in your life. What am I talking about? Let's say that you are a man or a woman and you are married to somebody from a foreign country. That's a concern. Or let's say that you're a young man and you're living with somebody. You're an American working in a defense contract position. You have a clearance and you start dating a woman from Russia, for example. Our office deals with a huge number of cases with people dating others from Russia. That creates a security risk in the eyes of the United States government. I'm happy to tell you I have won those cases. I have won cases for Iranians, Iraqis, Egyptians. You can win these cases. Remember that theme I told you I was going to repeat. Don't be discouraged. You can win. It just takes a tremendous amount of hard work. Another area under Guideline B called foreign influence is shared living arrangements. If you're living in a home and 2 or 3 people are living with you in a large home, but they're from different countries, that's a concern. And you're probably asking yourself, wait a minute, how is the government going to find that out? And the answer is the government's going to find it out when you fill out your SF-86, or the government will find out when you tell your FSO at your company because you have a reporting requirement. Many of the defense contract companies in the United States that are multinational require their employees to report foreign travel. Some of them have forms that you must complete. And on those forms, they ask about foreign contacts. We've had many cases where some of our male clients have gone over to foreign countries and taken escorts out for social events. How did the government find out? Well, because a coworker said something, or my clients honestly reported it as they should, and now the government has sent them a statement of reasons. For all of these incidents, and I've just touched on a few, there are what's called mitigating factors. And the mitigating factors are the evidence that I prepare, my staff prepares, in the form of a trial notebook that's introduced at the formal hearing and that overcomes the allegations of the government. Your evidence becomes so compelling that the judge says, Attorney Edmonds has mitigated the concerns of the government, and I don't feel any longer that there's a heightened risk of security, and I am going to give Attorney Edmonds' client a favorable ruling, and they shall have their security clearance. How do you develop that evidence? Call me. I can't give you, this is not law school, and there's no way in the short duration of this seminar I can tell you how to develop the evidence, but I'm letting you know that it can be done. And if you doubt that, again, visit the websites. Click on recent victories or favorable decisions and scroll through, and I'll bet you'll find a case just like yours. Now, we've talked about guideline B, which is foreign influence. There's another guideline, and it's the third one in 5220.6, and it's called guideline C, which is foreign preference. And here the concern of the United States government is that the individual acts in such a way as to indicate a preference for a foreign country. And I talked a little bit about this earlier. What could you do to show that you prefer the country you came from over the United States? One is that you're still carrying a foreign passport. This is a huge issue. And we have successfully dealt with this issue at my law firm, but it's a huge issue because many of my clients say, wait a minute, Mr. Edmonds, I can't get into my country without my foreign passport from that country. Some of you say, wait a minute, I don't want to give up my retirement benefits in Germany and give up my passport. I am aware of all of these concerns, and I've dealt with them before. I have the solution. But that's one of the biggest key areas about foreign passports. Another one is that you have served in a foreign military. Well, I've handled numerous cases from Israel. I have Israeli clients. Military service is compulsory in Israel. And yet, even though the United States knows that, under Guideline C, military service can cause an SOR to be generated. Citizenship is another area, and financial interest is another area. Voting is another area. I've had clients that have exercised their voting rights in a foreign country, and they did it by mail. And the United States found out about it and issued an SOR. Now, one of my favorite arguments in these cases to judges is that you and I don't pick our parents, and we don't pick the country that we were born when we were babies. There are ways to rebut all of these assertions. And I have done it on numerous occasions. So now you've been exposed to Guideline B and Guideline C. It's a very, very complex area. You're in an environment that's not friendly, contrary to your perceptions when you first make contact with a government attorney or representative. If you're active duty military, you're entitled to a personal appearance, which is a slightly different format than the hearings I've been talking about. And in fact, the hearings can be conducted in a variety of different locations, with different rules, and with different people. When you go to NSA for a hearing, for example, you'll have a minimum of 5 people facing you in the hearing room. When you go to the CIA, you'll have 1 or 2 people in the hearing room with you. When you go to the Defense Office of Hearings and Appeals in Arlington, Virginia, you'll have 1 administrative law judge and an attorney. In personal appearances that I talked about a few minutes ago, there may not be any opposing attorney. It'll be you with your counsel and the judge then becomes an interrogator. And the judge gets to ask you questions as if they were a prosecuting attorney. Of course, their role is to gain as much information and insight into your case so that they can make a fair and impartial hearing. But when you're subjected to their cross-examination, you're going to feel awkward. I know, because I've attended those hearings with clients from Hawaii, all over the United States. I've done video conferencing when my clients were sitting in Afghanistan and in Kuwait, and I was in Arlington, Virginia with the judge. And after the hearing, the client said, I couldn't believe how aggressive the administrative law judge's questions were. And you have to understand one thing. The judge is a trained adjudicator. They have a legal background. Some of them were prosecutors, some were attorneys in private practice. They are trained at the skill of cross-examination. The government attorneys come from a varied background as well. And you, how many cases have you presented in a courtroom? As an IT person, as a computer science person, as an engineer, how many legal cases have you presented yourself? And we both know what the answer is. And that answer definitely speaks to why you should consider hiring an attorney that's experienced and knows how to handle these cases. It's your career. How important is that career to you? Call my office, 800-481-2526. Speak to one of the most experienced staffs you've ever encountered in the United States in the area of national security. And if you're active duty military, I've handled court-martials, boards of inquiry, security clearance matters for over 34 years. I speak your language. I represent men and women in uniform around the globe. It's a tremendous honor for me to do that. Don't hesitate. In today's world, which has been shrunk by PDAs, smartphones, the internet, telephone, call me. You'll be amazed that you'll receive a response the same day. And I want to point out one other thing. My office is geared toward client service. When you retain the Edmonds Law Firm, no matter where you are in the globe, we are going to respond to you electronically with email, phone calls, and you will be in constant communications with us. I can't guarantee you or promise you a victory on every single case, but I can guarantee you that you will never have a staff work harder for you than the staff at the Edmonds Law Firm. We're trained professionals. All the lawyers that I hire are litigators. I don't hire attorneys that can't handle the courtroom. And I don't hire people that can't become passionate about your career. So thank you so much for allowing me to talk to you today. I want to answer your questions. I hope to hear from you. Take me up on my offer. If you don't have a copy of the directive, please call me. If you're involved in one of the processes that we've talked about, you just received a statement of reasons, you've already responded and you found out you weren't successful, call me. I can help you out at any stage. Even if you went to a hearing and you just found out you lost, there are other steps that you can take, and I'll take them with you. You have another round of appeals. If you've missed deadlines, let me know. Thank you.